right. The Commish Radio Show, Legal Standpoint with Michael J. Todd. I always like to mess with my boy about his name because, I think, like a Fred G. Sanford type thing. That's why I be doing him like that. He just glares at me like that. Only because his family happens to be winning football championships in the state of Texas, do I allow him to get away with that?
Is that it? That's the only reason?
That's the only reason.
That's the only, Oh, okay.
Oh, wait a minute, hold on. And because he paid for this show.
hey, Ronald Reagan, I paid for this microphone.
And, this is what we're about, It's like we said before, the best radio show from Como to the Congo, but, we often say it when we do this segment is that we're not just a bunch of brothers just talking stuff. We actually know our stuff, because Attorney Todd is one of the best lawyers in the state of Texas, and, well, you know me, I'm just one of the best historians. So I also happen to have gotten one of the best historians in the state of Arkansas, Cousin Clifton. Hey, man, tell them who you are, man.
Yes, I'm Clifton Collier. I teach school in Marianna, in Forest City, Arkansas. I'm from Marianna. Both of those cities are in eastern Arkansas, what's called the Arkansas Delta. Very poor area. A lot of needs there, but I'm glad to be here today.
All right. So we're just going to kick it.
Yeah.
Like we've been doing.
Well, I'm glad you introduced our special guest, Clifton Collier. Yeah, I did. He's a old Tennessee State grad.
Tennessee State grad.
Tennessee State.
Yeah, that's where
he was walking on the campus with somebody that's famous and special.
Oh,
Same time, came in as a freshman year together.
Man, you telling tall stories.
No. He walked the campus with somebody that everybody knows.
Man, you telling tall stories.
No.
Who you telling the story about?
Clifton, who were you walking the campus with?
Well, this is not a tall story. This is a Tiger story, Tennessee State Tigers.
Okay.
But, I came in as a freshman back in 1971, and one of my freshman classmates was Oprah Winfrey.
Oh man. Okay. Yeah. See, you went to class with Oprah?
Well, I didn't have classes with her, but we were freshmen together.
Yeah, is that right?
Yeah, in 1971. So
I asked him on the way out here. I was like, man, what was Oprah like, man? Back in the day, freshman year.
Why you asking her like that? What was she like?
What was she like? Was she the Oprah? But you know what? Tell what was Oprah like back then?
We were just out of high school, so we were still kids. We might not admit it, but we were still kids. But Oprah never seemed like a kid. Oprah always, she carried herself differently than we did. She spoke totally differently from what we did, and she seemed to have a plan even as a freshman in college. She won Miss Black Expo, and then she ended up doing a TV show. Well, not a TV show, but she was on TV, a news person, while she was still in college.
So it wasn't nothing new to her.
No. And I think from there she went to Chicago, I believe.
Yeah. Okay.
Yeah, but those were some good days back in Tennessee State.
Back to Tennessee State.
You know what? Just recently, I saw a picture from him Clifton, from back when he was at Tennessee State. Mm-hmm. You can't tell it now, but he had a big fro, right? A dashiki.
Right.
Man, he looked like he was
real militant.
He looked like he was a Black Panther, man.
He looked like one of them brothers that was gonna get kicked out of the Tennessee State legislature.
Yeah. Oh yeah.
He bring it on.
That's what you look like.
Hey,
that's what you look like.
Just protest
I told you, it's gonna be a history thing. I told you that. I'm just trying to extend that yard, brother. That's all. I'm just trying to get that yard out of it. That's all.
Yeah.
Okay, what's up, man? Yardage.
You know what? Yardage. Talking about the same stuff over and over all again. 3 things have come to my mind this week as I was reading, initially heard about and then read about the voting rights case that came out of the 8th Circuit. Three phrases came to my mind. The first phrase that came to my mind was 6.5, half dozen the other. What's that mean? Ed?
You didn't tell me it was going to be any math involved.
No, it's not a math. 6.5, half dozen the other.
You just said 6.5. That's math.
Yeah, man. Half dozen the other.
Half dozen another. That's still math. That's numbers.
But you know what? It's the same.
It's the same.
Think of this phrase: 2 ways to skin a cat. What does that mean?
Texas schools weren't that good.
2 ways to skin a cat.
Any way you can get it done.
Any way you can get it done. And then the last thing I thought about, as I thought about the Voting Rights Act, was heads I win, tails you lose. Because you know why? All 3 of those apply to the actions that the Republicans are taking to try to negate and erase our right to vote. 6.5, half dozen the other. It's the same. No matter how they're trying to come about it, the result will be the same. 2 ways to skin a cat. Whether we're trying to do it by saying you can't vote, like the passing of the voting laws themselves, or whether they're trying to foreclose access to the courts to enforce the voting laws. 2 ways. Mm-hmm. You follow that? 2 ways to skin a cat. And then the bottom line on all of it is what? Heads I win, tails you lose.
And I'm the one losing.
And we always losing, right? Because what we have to do is to keep our eye on the ball as it relates to what is happening here. Okay?
Now, which one of the amendments are we dealing with in the Constitution?
Now, this isn't an amendment. This is the Voting Rights Act itself.
No, I know, but the Voting Rights Act, that's what I'm saying, the Voting Rights Act, which one?
Well, it's based upon 14th, 15th
There you go, that's what I'm asking.
All right, okay,
all right.
I know that.
Okay.
But this is the Voting Rights Act.
No, I know, I'll just ask
All right.
for the reference for the people
Right.
that are listening.
Now, the one thing that we have to understand, when we think about those 3 things I just said, 6.5, half dozen the other, 2 ways to skin a cat, head I win, tails I lose. We have to be mindful of what the game is, right? The game, what they're trying to do is to deny black folks, brown folks, the right to vote. That's the end result, right? Now, we have talked in the past about different ways of how they've tried to do that, okay? They first passed all of these voter restriction laws throughout the country. You know, we've talked about that on this show before. We've talked about how there have been particular entities, such as the Public Interest Legal Foundation, the Conservative Partnership Institute, the Libertarian Freedom Works, all of these people who've been putting together all of those voter restriction laws and pitching them to legislatures around the country to do what? Restrict the right to vote, to give legislatures and Republican appointed individuals the power to oversee and to overturn elections. That's the first step. You follow me? We've talked about that.
Right.
You remember that, Ed?
Right.
You remember that? All right. And so we've had instances here in Texas, here in Florida, even in Arkansas, where the case that we're going to be talking about today is from Arkansas. But even in Arkansas, they've passed a long list of election laws. They you know, you used to be in Arkansas where if you didn't have your photo ID, you could go in and you could fill out a little
form.
affidavit,
Saying
affirmation, say, hey, look, I am a resident of, you know, Arkansas, a citizen of Arkansas, and I live in such and such an address, and you can vote, right? But they changed all that. If you don't have your ID now, they'll let you do a provisional ballot, and if you don't bring back a photo ID by the Monday after the election, your vote doesn't even count anymore.
Well, how do they know when you do a provisional vote whether or not it was your vote? I guess they can cross-reference the number of votes.
Okay, well, what do you mean? I'm not following.
Well, I'm following on this. Okay, I'm in Fordyce, Arkansas right now.
Right.
Okay, that's in Arkansas.
Right.
I just threw them off right there.
Right.
Yeah, you
I
did.
just threw them off.
Right.
You know where Fordyce is at.
Right, okay.
Redbud country. So I'm in Fordyce, and I don't have my voter registration card. And I go ahead and I vote provisional.
Right. So if it's a provisional ballot, it's not counted with the regular ballot.
It's not counted.
It's segregated off, and before that ballot can become a valid ballot to be counted, you have to bring back a photo ID by the Monday after the election.
So the Monday after the election, how do they match up my vote with my photo ID?
Well, the thing is, I mean, you voted before, so you know when you go in, you give them your ID. They had that long list, right?
Okay, there it is. So the name
Yeah.
is match out. Okay,
Yeah,
cross-reference
yeah,
with
they
the list.
cross-reference
Okay.
the list.
All right, that's what I wanted to know.
I mean, that is how you've been voting, right?
Yeah.
They do have a list, right?
I don't feel like the way you answering these questions.
Well, hey, I'm turning into a Republican, man. And we've been having some hang. I mean, that's
Nah,
how,
man,
that's how it
what
goes
you-
at your.
That's where you be doing people in your courtroom?
Yeah, sometimes, man.
yeah, sometimes.
Yeah.
Okay, I'm gonna be a hostile witness now.
Right. Yeah, but you know that's just an example of the laws that they've passed, and we've talked about it before. These laws that were passed in Arkansas to restrict the vote, the laws in Texas, the laws in Florida, the laws in Georgia, they have the same people pushing these to these legislatures.
Mm-hmm.
You know, I was talking to Clifton as it relates to or Cliff as it relates to the Arkansas legislature, and he made an observation about the legislature that, you know, a lot of the people down there, what are they? They're not too many lawyers in the
Right.
legislature.
A lot of them are farmers. They are business owners, bankers, that kind of thing. That they're not lawyers.
Okay.
So a lot of these long acts and bills and things, somebody's going to help them with
Right.
bottom line.
So and
Well,
what's
I mean,
that?
help them understand what they
Understand what they're voting for, right? On my behalf.
Right. So and what is their position about the fact that they're not lawyers, or I mean, are they proud of that or what?
I mean, yeah. I mean, this is the real America. You know, we don't have to have all these degrees and things. We know what's right, what's wrong. You know, God is on our side, so we gonna just do it our way.
Just do it their way.
Do it our way.
Well, that's a strange place anyway. I mean, Arkansas with that kind of thing.
I've been there all my life.
Yeah.
All my life.
Yeah. It's different. It's different. But the thing is, so these laws are going everywhere, being pushed by everybody, right? We talked about those different folks. So the first step, of course, folks, is they're trying to disenfranchise you from casting the ballot, right?
So you can't even get the ballot to even vote.
That's right. Then the second thing, that kind of goes into the 2 ways to skin a cat, right? You remember we talked about before, Ed, about the independent state legislative theory. You remember that?
Right.
And that was a theory that the Republicans came up with their congressional maps. Because what was happening over time was that the state legislature was passing an act that was gerrymandering all of their congressional seats. And then entities like the NAACP, you know, concerned voters, they were filing actions in state court saying that those maps were in violation of the state constitution. And individuals started having success around the country because the federal laws sometimes are a little onerous. So you would go to a state court, apply the state constitution or state laws, and they were starting to get results with that. They had a big case in Pennsylvania where they were able to change the whole balance of the congressional delegation in Pennsylvania because they went to the states with respect to saying the way that the legislature did it was in violation of the state constitution. So the Republicans came up with this second attack because we talking about 2 ways to skin a cat. Can we keep them from voting, right? So then they said, well, let's do this independent state legislative theory. And that means that the state courts should not be able to oversee and to call balls and strikes as it relates to U.S. congressional maps. That's something that's delegated to the legislature, and the courts have no business doing it, no business overseeing it. And that went, initially it was considered to be a fringe type theory, and it went all the way to the Supreme Court. It lost a 6-3 vote, but we had 3 justices that were thinking, hey, that sounded good to them. And you remember we talked about it before, Ed, and I talked about how important it was that case actually lost. You remember that?
Right.
All right, so that's one way.
6-3. Now, who voted 6-3? Who was the 6-3 on?
Well, the thing is that you had Gorsh, you had Clarence Thomas, and you had Alito. All three of them were the three that voted for that. But remember what we're talking about now. And the thing is, folks have to understand this. 2 ways to skin a cat. The voting law will keep you from voting. If that doesn't work all the way, we're going to set it up where we can gerrymander it, and we don't want anybody to look at how we did it. You follow what I'm saying? To do what? Entrench ourselves in power that we can continue to have super majorities in these state legislatures, okay? But they lost that, right? So they lost that. So that's out the deal. So everybody, including myself,
Move your mic around.
we did a little sigh of relief, as it relates to that. And then last week, I read about this case, this voting rights case for Section 2, and Section 2 is really the only viable section we have, where the 8th Circuit has affirmed a decision out of Arkansas.
Arkansas again.
Out of Arkansas.
That's why you brought him here.
That's why I brought him. It was an Arkansas case, so I said, you know what?
Congratulations, you got out.
And so, but it was an Arkansas case, and in that particular case, what was going on was that the legislature again gerrymandered the state house map. The state house map. And so the NAACP and another entity, they filed an action in federal court.
The NAACP in Arkansas.
In Arkansas.
So the NAACP in Arkansas still fighting for justice.
Still fighting for justice.
So, when they start talking about the NAACP, I'm going to talk to the people that are listening to us at home. NAACP in Arkansas, the same people with Daisy Bates, the Little Rock Nine. They still doing that thing. So go ahead, talk, counsel.
Right. So they filed this action. And so they say, right, that the maps, because there were 100 House seats, and black folks were only allocated 10 of those by having majority black areas. And they said that based upon their
100 House seats.
100 House seats. So we talking about 10 out of 100.
And how many the percentage of black folk in Arkansas?
You know what? We went through that. It's about 16%.
I know I said before that I wasn't about math, but I got a pen and pencil now.
Right.
Yeah, it's somewhere around 15%.
15%,
More or less.
Right.
So we short.
Yes.
Right. So they went to court and they said that we should have at least 6 more seats.
Okay.
All right. Now, what happened then was this. The judge who was hearing the case was a Trump appointee, okay? And even though no one raised it as a defense, all these people have been sued by the NAACP. We've got the board, the Arkansas Board of Appointment. We've got Sarah Huckabee Sanders in her official capacity as governor.
Wait a minute, didn't she used to work for?
Yeah, she used to work for Trump. She was his press secretary.
Yes.
At the White House. Yeah, she was something else.
I know.
Yeah,
I know. I got all kind of jokes to talk about.
Right.
But I'm just gonna leave it alone.
And
Right.
She has larger plans than being governor, though. So.
She has larger plans than being governor.
Yes, she does.
But everything about Huckabee is large. Go ahead.
Yeah. But I heard she has a good head on her shoulders.
All right.
But the thing is this. The chairman of the Arkansas Board of Appointment, the Secretary of State, the Attorney General of Arkansas, all these people are in this case, and no one raises the defense that the NAACP does not have the right to bring this suit against them. Nobody raises that except the Trump-appointed judge.
Wait a minute. Now the judge says the NAACP needs to stay out of it.
Well, what he asked and what he decided was that as he looked at the legislative history of the Voting Rights Act that was passed in 1965, it was recodified in 1982, and he came to a legal conclusion that the way it was written, that the only person that can bring a suit to enforce the Voting Rights Act is the Attorney General of the United States. And so he threw the lawsuit out.
Was there any precedent for that decision?
There was, well, I'm going to tell you what spurred it on. We talked about a while ago how we had some Republican individuals that started pressing this independent legislative theory. Remember? We just talked about it. And that ended up, even though everybody thought it was a fringe theory, that caught fire. It goes to the Supreme Court. It loses 6-3. About a year ago, there was a voting rights case that was before the Supreme Court. And in that voting rights case, the plaintiffs were going to win. So that means that the people who were bringing the suit, generally black folks, that they were prevailing in their suit, their case before the Supreme Court. Justice Gorsuch, he concurred in the opinion. He said, okay, I'm going to agree with this one, but I'm agreeing with it because nobody brought up the fact of whether they had a right to bring the lawsuit in the first place. I'm just going to throw that out there. Nobody said anything about that, so I'm going to agree with this decision. And from there, that was a signal to every litigant, and I've told you all before, we have groups that are just out there hanging on every word, and what they're trying to do is they are going to take whatever is thrown out and they're going to start lawsuits to try to make these theories become reality. And we're going to talk some more about that after the break, right here.
Yep, after the break. Victor, let's play a couple of drops and we'll be right back after this break.
Hi, my name is Gail Todd with Townview Realtors. If you find yourself in the market to buy, sell, lease, or maybe you want to be a part of this hot real estate market by investing, just give my team of professionals and I a call at 214-675-9572. Again, that's 214-675-9572. Or you can email me at gtodd88@yahoo.com. With me, it's all about you.
Who was that masked man? You mean you don't know? That was no masked man. That was the Commish. Saturdays from 5 to 6 p.m. on the Fishbowl Radio Network.
What's up, beautiful peoples out there? It's your boy Mar, a.k.a. Cool Pop Watson, baby. Make sure you check my man out 3 to 5 every Saturday. Commish Radio Show. Make sure y'all come check my man out.
Hello out there. My name is Byron Williams, former NFL player. I'm with the NFL Players Association, and when I'm not in the community, I'm listening to Mr. Ed Gray, the Commish.
All right. We're back again, Commish Radio Show, Legal Standpoint with Michael J. Todd. Want to send a shout out to all those people who are listening and looking at us in Marianna, Arkansas, Fordyce, Arkansas, Bearden, Arkansas, Stamps, Arkansas, Waldo, Arkansas, all them Arkansas.
You have a map over there, don't you?
No, I'm just my folks from Arkansas.
Wait. I was about to say you just country.
Yeah, I'm just country. I'm just country. I grew my dad was born in Fordyce, and I know about Bearden. I know about all of them.
All right.
So, counselor, you got to speak the language of the people in Arkansas.
All right.
Yeah. So
what are you saying? People in Arkansas don't speak
no,
like folks
just
in
the way
Texas?
you say. You don't say Fordyce. You say Fordyce.
Oh.
Yeah.
Oh, really?
You don't say Bearden. You say Bearden.
Oh.
So those are the ways you talk, like Waxahachie.
Oh, okay.
Not Waxahachie.
I don't know how the Arkansas people gonna take that, man.
Well-
I mean, I did call them country. But
No, you called them country.
I did, but guess what? But I got a beautiful wife from
I-
Arkansas.
I'm not going to ask if she country.
Yeah, no, she's not country.
So you're going to lose a viewer, man. But I ain't got to go home.
I said beautiful, so she smiled about that. I know that.
I ain't got to go home with you. So go ahead and talk, man. What's
All right.
up?
So the thing is this. So this judge takes it upon himself to try to determine whether there is a private right of action. And let's talk about what a private right of action is. when a statute is passed by Congress, and let's say we're talking about the Voting Rights Act, let's say we're talking about the Civil Rights Act, things of that nature, those acts usually give some type of proscription or saying you can't do something. You can't discriminate. You can't enact laws, voting laws that's going to keep people from being able to vote, all right? And so generally when legislatures do things like that actually do limit a person's right to vote, the question is, how do we get redress, right? Now, if the statute specifically says any person or any aggrieved person or anything like that, then of course, then that is what we call an express private right of action. You know, you as an individual could walk in, you the commish could walk in and file a lawsuit and say, I've been aggrieved by this particular action and it kept me from effectuating my vote, all right? Now, if there's not an express statement in the statute, you know, any person, any aggrieved person, anything like that, then what happens then, the court has to look to see if there is an implied right of action, all right? And that's determined by courts. And what they have to look at the language of the statute. They have to look at the makeup of the statute. And if there's ambiguity and things of that nature, they can look at the legislative history of the statute to make a determination of what did Congress intend when they passed this law. Now, since 1965, there has been no question that there was a private right of action. The dissent in the Arkansas case listed over 400 cases that have dealt with individuals like the NAACP, Miss Jay-Z May, you know, people just coming in saying that the law is not being applied properly, right? And they have been able to litigate those things, over 400 cases throughout this country. And today, as of last week, we have a circuit that encompasses 7 states that now has a ruling that says that only the Attorney General can bring this action. NAACP, you go sit on the sideline. You don't have nothing to say here. Shut up.
Yeah,
you follow what I'm saying?
Yeah, because you talking so pretty and everything. I'm looking at you going like, dang, you talk pretty, man. What that mean?
What you mean?
You talk like that at home?
Wait a minute. What you mean pretty?
I mean,
hey man, wait a minute. I don't know what.
I don't know, man.
I don't know how to take that.
Look
man.
here, man. I'm from Oak Cliff, man.
I'm thinking about Goodfellas. I mean, like pretty. What you talking about?
What was that word? Amber what?
Amber what? Oh, ambiguity. Oh, okay.
Oh, big words. That's make it pretty.
Ambiguity. Yeah, ambiguity. Yeah.
Hey.
Well, you know, I mean, ambiguity. Yeah.
Ambiguity.
Yeah. So the
you
thing
got
is,
Victor over there trying to look that up. Victor.
Yeah.
Look that up.
So the thing though is that we have this situation now where this court has said that no one but the Attorney General has a private right of action to enforce these laws, and a stat was quoted that there have been 100. I said it was 400 that have been litigated. There have been like 187 that have been successfully litigated, right? And only 15 of those involved the Attorney General. So that means
Attorney Generals, generally speaking, haven't been part of this process.
Right, haven't been part of this process. So what you have, if 187 minus 15, that's 172 successful cases that have been started by the NAACP, interested people, you know, the Defamation League, the American Civil Liberties Union. Anybody who's come forward with individuals that had standing, meaning they were individuals within that state that were aggrieved by the actions of the legislature, that they have found the legislature did something improper, those people would not have been able to bring suit. And my thing is this, Ed and Cliff, what good is a right if we, when we're saying our government has done something improper, that you can't get even a hearing about it, let alone redress? I mean, is that America? Is that how we work now these days?
Yeah. Let me ask a question for clarity, though. So if my voting rights are violated, they don't allow me to vote for whatever reason, I cannot, as an individual, take that to court. I have to go to the Attorney General and have them to
take it on?
If it's going to be under Section 2 of the Voting Rights
Yes.
Act, right now in Arkansas, the only person that can file that suit would be the Attorney General
Of the United States.
of the United States.
So remember in Arkansas, I have to contact the Attorney General of the United States and tell them that they wouldn't let me vote.
That's correct. Now, but let's think about this now. Think about the magnitude of that decision. There's one federal government. We've got U.S. elections. We've got state elections. We've got county elections. We have city elections. We have, all type dog catcher elections. Everything. So out of all of these different elections that are by different entities, multiply that by each county, each state, hundreds of thousands of possible violations that if this position prevails, only the Attorney General would be able to file suit. How could that be right?
He or she's not going to have time to do all that.
Won't have time.
If they had the will to do it.
Right.
Exactly.
If
You're
they
right.
had
If
the
they had the
will.
will to do it.
Because the thing is this. If we're talking about a Trump administration,
I'm not going to look at that.
hey, they're not going to be involved in doing what? Filing something
not
to say
gonna
that the black folks in Texas didn't get a chance to vote right? Or that the Native Americans in Oklahoma didn't get a chance to vote? Right? Or Jewish folks, in New York couldn't vote? They're not going to be concerned with those things. So what this does, though, is that it gets back to what we've talked about. We've talked about since Trump has been in office, there has been nothing but a protracted effort to grab power. People have talked about democracy. Back when I was growing up, the Republicans would win. Well, back then it was Democrats would win. The Democrats would win, and they would say, well, that's the Democratic way. We outvoted you, right? And now when it's gotten to the point where you have coalitions of people, right? You have coalitions of black folks, white folks, Hispanic folks, Jewish folks, Asian folks who are voting and starting to win, then we're changing the rules. And we're changing the rules to do what? To maintain power. That's not democracy. But what we have to be mindful of is that they are doing this, what? 6.5, half dozen the other. Whether they're trying to keep you from voting at the voting booth, whether they're trying to keep the state courts from looking at the action, whether they're like here trying to keep federal courts from not being able to entertain these actions unless the Attorney General is involved. All of those things are doing what? To bake in the power grab. And what we have to do is, folks, we have to be mindful of that. We can't take one victory. We won the independent state legislature case, 6-3. That's over with. We're feeling good. But now what are they doing? 2 ways to skin a cat. They're trying to come back another way. To do what? To get heads I win, tails you lose. We've got to be mindful. We've got to be mindful. This decision, this decision is, it's mind-boggling. I read it. It's 34 pages. Because let me make sure I get a procedural posture to this. That's another word. That's one of them legal words.
Yeah, there you go. There you go again. Since you like Reagan, there he goes again.
Procedural posture. That means, how the case has, how the case has gone.
Say that one again. I'm gonna use that one when I get home.
Yeah, procedural posture.
Okay.
What's the procedural posture of the case?
Yeah. Okay.
Well, it started so and so, and then it. Okay. So in this particular
apply
case,
that in the proper context.
right. Now, in this particular case, as I stated, the case was decided by the district court judge. All right. He on his own. We call that suspente. On his own. Right. The district court judge on his own, suspente, determined that the plaintiffs didn't have the independent right to sue. So then the case was appealed to the eighth District Court of Appeals, the 8th Circuit Court of Appeals. I'm sorry, and so the Court of Appeals usually would have a lot of judges on the Court of Appeals. It might be 15 judges on the Court of Appeals. But what happens is that all 15 judges don't hear the case. They will assign 3 judges from the 15 that function as a panel to hear the particular appeal of that case. Well, that case went to the 3-judge panel, which included two Bush appointees and also a Trump appointee. The Trump appointee on the Court of Appeals wrote the opinion for the Court of Appeals. And it basically, in a 2-to-1 decision, agreed with the district court judge that there was not a private right of action by the NAACP in this particular case. So what's happened now is that we have, and I told you before, since 1965, people have been filing suits on these cases, every year. But we've had decisions, and guess what, Ed? We had a decision a week before, on November the 10th, we had a decision from one of the most conservative courts of appeal in the country that said there was a private right of action. And guess who that Court of Appeals was?
Who was it?
The Fifth Circuit Court of Appeals, okay, which encompasses Texas. So the Texas judges listen to this case, and everyone knows that some of the craziest decisions come through Texas because the Texas Fifth Court, the Texas Court of Appeals for the Fifth Circuit is one of the most conservative. But they heard the decision, and they looked at all of the cases that have been since 1965. They looked at the legislative history, and they said, we consider most of this work on this issue to have been done by a previous voting right case. And they said that this really ain't no big deal. I don't even know why we talking about this. Let's move on to something else. So we've got the most conservative district or Court of Appeals out of Texas that said this ain't no big deal. But we've got the 8th Circuit that is saying what? Oh, yeah, it is. We're going to throw it out. Now, what happens, folks, is this. If you've got all the circuits saying the same thing, then the Supreme Court never takes the case up. And remember when we started this conversation, I said that Gorsuch, one of the Supreme Court justices, about a year ago, he's the one that signaled out to everybody, yeah, I'm going along with this case on the voting rights here, but nobody brought up this issue about private right of action. So he's like, hey, give it to me. Send it to me. Now that we've had a contrary decision out of the 8th Circuit with respect to what the 5th Circuit has says, we now have a conflict of circuits, which then would allow the Supreme Court to bring this case up to make a decision, to smooth out, to figure out which way the conflict will go. And so when we've got folks like, all of the Trump people, Kavanaugh, we've got Barrett, we've got Gorsuch, those 3 people with Roberts and Alito, and one other one, and
Are you leaving them off on purpose?
Oh, Clarence Thomas, I forgot about him, man. I've been trying to forget him for years, man. And Thomas, it really could be a situation. Yeah, it could really be
the black guy. He leaves the black guy.
What was that movie? It was something. It was a movie, man, where they wrote a book about it too. Something about somebody sitting by the door.
Oh, spooked by the door.
Yeah.
You want me to say it? Okay, all right. Yeah, I ain't scared. I'll say it.
Somebody's sitting by
He
the
knew
door.
exactly what it was.
Yeah.
Yeah. See, that's what we do, Clifton. See, the things he can't say, I can see the point to me. I didn't say it.
But the thing is, so this could really be an issue. Now, I am hopeful, though. I am hopeful because back in June of 2023, there was a voting rights case that was out of Alabama that everyone thought that the Supreme Court was going to say Alabama's map is okay. But there was a really weird configuration of justices. We had Kagan, we had Sotomayor, we had Brown Jackson, plus Roberts and Kavanaugh. They branded together in a 5-4 decision and said that the Alabama map was improper and sent it back. Now, of course, the Alabama legislature, the Supreme Court gave them instructions on what to do. Alabama legislature, they said, we ain't doing that. And they did another map that didn't do what they said, and now the Court of Appeals for Alabama is throwing it back to them saying, I don't understand why y'all being so disrespectful to us. So hopefully, in that particular case, Roberts talked about how individuals have a private cause of action under Section 2. So really, I think the whole key is going to come down is to make sure that Kavanaugh and Barrett are on board like they were in the independent legislative case, that they're on board with respect to this particular case being thrown out.
All right.
You know? So, but the thing is this. The thing that I wanted to talk about, and the reason why we wanted to talk about this today is because we have to be mindful of what I've said 10 times. But, I know everybody need to hear stuff 10, 15 times for it to sink in once. 6.5, half dozen the other. 2 ways to skin a cat. Head I win, tails you lose. They are trying every way they can to disenfranchise us, to bake in them being in power. Whether it's keeping you from going to the ballot box that day, whether it's trying to keep the state court from overseeing what they're doing, or whether it's trying to foreclose the federal court from being able to hear cases brought by private individuals. No matter which one of those options they take, it leads to people not having a voice, not having an opportunity to be able to get wrongs redressed. And so we have to keep doing those 3 things that we've always talked about and that my hero Frederick Douglass has talked about. Now, Cliff, you know what I'm talking about when I say?
Agitate.
Well, agitate's one of them because we got to agitate by voting. Mm-hmm. We got to make sure that we're supporting these entities, the NAACP, the National League of Hispanic Voters, the American Civil Liberties Union, those entities that are filing these lawsuits, these civil rights, these voting right lawsuits. We've got to support them. We got to give them some money. We got to make sure that they can go down and they can do the fight, because we need the ballot box, we need the jury box, and for self-defense and to protect those 2 liberties, we always need to be mindful. We need that bullet box too. So everybody need to be a strong 2A person right now.
Yeah.
Now is not the time to be talking about, hey man, we gonna give stuff up.
Yeah, and if I could talk about why
You
this.
got 2 more minutes.
Okay, why this is important historically, after slavery, and you mentioned the 14th and 15th Amendment earlier, the only way that the 3 branches of government saw that these free slaves could be free and safe, make them citizens, 14th Amendment, give them the right to vote where they can vote for people who represent their interests, give them power.
Right.
And now those things are being taken away from us. But almost 200 years later.
Right. And you know what?
On our watch, though.
On our watch. And the thing is this: Merrick Garland, he brought out something that I didn't even know. The Department of Justice was formed back after the Civil War to protect the freedmen, to protect those individuals from the vigilantes, right? And they were working, it was working well until I think it was 1877 when they made the compromise.
Right.
And they removed all the troops from the South, which led to what? Jim Crow, secondary citizenship, and segregation. They are trying to take us back. And as Cliff just said, we cannot allow that to happen on our watch.
And we won't allow that to happen on our watch because you're listening to Legal Standpoint with Michael J. Todd. We're glad we had Clifton here to bring us back to speed of how the 14th and 15th Amendments are affecting us in Arkansas and across these United States, because as we know, it's winter in America, as Gil Scott Heron once said. You know, the Pilgrims once welcomed the Indians once welcomed the Pilgrims, and now we're living in a country now where the buffaloes no longer roam, but we're living in a country now in which, well, American democracy is at stake, and it's ragtime around the corner, as Gil Scott Heron once said. So stay tuned and learn more, but most of all, agitate. Thank you for listening to Legal Standpoint with Michael J. Todd. All right.
Everybody, thank you.
Hey, you know, whenever I want good Cajun food, I go to Thibodeau's, located at 107 North Cedar Ridge in Duncanville, Texas. They're really hot, just like the Commish radio show in Thibodeau's. Hot as this gumbo. We will see you later at Thibodeau's.